we were on ground 2,
Yes.
and we were still on the absence of safeguards in the bulk regimes and in Part 5, and that of the claimant's skeleton 26 and following. The claimants say that operational purposes, which as you'll recall we were on as well, that requirement needs to and doesn't involve identifying categories of individual selector, such as, they say, persons searching on websites concerning extremist material. And our submission in response is that that approach impermissibly seeks to limit the meaning of what a category or type of selector is. And the European Court in Big Brother Watch did not do so. And it is, we submit, entirely unsurprising that they did not do so. Indeed, on the contrary, they seem to have been very well alive to the difficulties that sort of thing would have created. So if you go back to Big Brother Watch Grand Chamber, behind tab 56 of the authorities bundle, and you go to page 2300, you will recall paragraph 345 on 2300, so tab 56, 2300, paragraph 354, which refers in the second and third lines and involves the European Court recognising, as they put it, the inherent need for flexibility in the choice of selectors. And that sits in a context where they had previously recorded at 292 their understanding that many thousands, last 2 or 3 lines of 292, many thousands of selectors might be used, which would sometimes need to change rapidly in order to keep pace with fast-moving investigations and threat discoveries. So they were well alive to that logistical and practical issue, and it formed the backdrop to what they said in 354. Obviously, the judgment needs to be read whole and fairly. It might also be thought, and I said that the Strasbourg Court was well alive to the fact that the IPA had in fact been passed, even though it wasn't directly before them, and they themselves noted at 184, page 2260, the structure under the new Act, and one of its features being the operational purposes feature. And it may very well be that it's that sort of thing that they had well in mind when they referred to the types and categories of selectors.
Sorry, paragraph?
It's paragraph 184 setting out, 183 starts a little section which sets out interesting provisions, even though it wasn't directly before them, of the 2016 Act. And they included in that the operational purposes provision. So we respectfully submit in relation to this criticism that it is not something on which the European Court was insistent, and for good reason. See those references. The claimants also submit that the operational purposes under the new legislation, the IPA, are really no more than equivalent of the descriptions of material in the Secretary of State's certificate under RIPA. You remember that submission, which were found, it was said, not to be good enough in BBW Grand Chamber, but that is wrong, we submit. The European Court, in their judgment, said that the descriptions in the certificate were, as they put it, an important safeguard, but pointed out the fact that there had been criticism of the fact that the descriptions were in very general terms. That's 386 of BBW Grand Chamber. And there was no control within the legislative regime over the generality of that certificate, and nothing in the statutory framework which required the certificate to contain any level of detail beyond the statutory conditions for interception themselves. Operational purposes, as you know, under 142, under the new Act, however, and by contrast, do need to be developed. I'm not going to go back over all of the requirements in section 142 and the way in which that links in with the Judicial Commissioner assessing and reviewing necessity and proportionality of a warrant, both in relation to the obtaining and in relation to the selection for examination. But they are on no view, I respectfully submit, the same as or comparable to the mere requirement for necessity that was all that you had under section 8.4 of RIPA. And moreover, there is and was no equivalent under the old codes and regime under RIPA to what you now find in the passage I took you to from the interception code that now exists behind tab 90, the relevant paragraph, or the particularly relevant paragraph, being paragraph 6.62, as you will recall from yesterday, at page 4418. And all of the provisions in the new Act and the new code are precisely designed to deal with a problem that the description might otherwise be thought to be too general. So not merely do you have that front-end loaded safeguard or set of safeguards that I went through yesterday, but you also have, let's not forget, the IPC doing its regulatory work behind the scenes, and after the event by way of auditing and checking and reviewing how the thing works in practice. You will also note in relation to the JC, sorry to jump around in terms of points of time and when the safeguarding cuts in, but once you introduce the Judicial Commissioner regime, you destroy the vice that was referred to by the Grand Chamber at paragraph 383 of their judgment, which was obviously an integral part of the reasoning, where they said in the first sentence of 383 on page 2307, in the present case, the absence of any oversight of the categories of selectors at the point of authorisation was a deficiency in the section 8.4 regime. Well, that deficiency plainly no longer exists. You'll be aware in relation to the other features of the new regime, just looking at the other context, the different parts of the Act, that each of the bulk powers in Part 6 and Part 7 contains similar operational purposes requirements for the references CR skeleton in this core bundle, page 97, paragraph 42. The claimant complains that Part 5, that's EI, does not contain the operational purposes requirement, but that we respectfully submit is because it's a targeted power, but which already limits the subject matter of warrants to matters such as a particular person or organisation or a group of persons sharing a common purpose or a single investigation or operation. See for that purpose section 101 of the IPA at page 2753. And the same point applies in relation to targeted examination warrants under Part 2 of the IPA, which the claimant complains about at paragraph 27 of their skeleton. See for that purpose section 17 of the IPA, dealing with the subject matter of warrants. So the basic answer is that even if a parallel requirement for types or categories of selectors existed in relation to those other powers, it would be met. That's the point. But in any event, for the reasons I gave yesterday, it isn't appropriate simply to read across a requirement from one set of powers in the new Act to other sections or other different types of power provided for in the Act. So turning then to the claimant skeleton at still on the absence of safeguards under the Buck regime, that's all I wanted to say about independent authorisation of categories of search terms. There was then a series of submissions made, reflected in the claimant skeleton to this court at paragraphs 30 to 33, under the heading "No requirement for separate and internal authorisation of strong selectors." Remember that point. And so far as that is concerned, the government has accepted that BBW Grand Chamber sets out a requirement for internal authorisation of strong selectors linked to identifiable individuals when conducting selection for examination from bulk intercept. The Grand Chamber's reasoning at paragraph 355 is where you find it, at page 2300. There have been changes in the Security and Intelligence Agency's systems to require internal authorisation of such strong selectors in those circumstances, and they have been publicly announced. See for that purpose, I don't need you to turn it up, but see for that purpose, you'll note the written ministerial statement of the 31st of March 2022 at supplemental bundle tab 15, page 202. So although the Part 6, Chapter 1 regime was not in accordance with law on the reasoning of the Grand Chamber prior to that date, it is now. So that's the short answer. There's nothing wrong with that. The requirement has been made clear and is public. Our submission is that the same requirement cannot be read across to other powers in the Act. I don't repeat all the notes of real caution about the importance of these powers and the different segments of power, the difficulties of this court just simply trying to read across without the facts and without the assistance that you might have derived from the court or tribunal below. So I just wanted to note a couple of, or a few points, if I may, in relation to some of the other segments of power in the IPA. Part 5, as you will recall, is a targeted power, and it authorises interference with equipment for the purpose of obtaining material falling within the specific categories. I gave you the section earlier. The specific categories set out at section 101, sub 1, A to H, page 2753. And my submission is that that's different because the material within those categories is intrinsically of intelligence interest, even though its collection might involve a significant amount of data, but it's intrinsically of intelligence interest. So the warrant itself already provides the type of safeguard to which the strong selectors requirement is directed. Part 6, Chapter 2, concerns both a different type of data, bulk communications data, bulk CD, and a very different factual context. And the use of search terms against a pool of CD acquired from telecoms operators is not equivalent, we submit, to the use of strong selectors to target individuals' communications on an ongoing basis. There's no equivalent within Part 6, Chapter 2 of the bulk interception process as explained at paragraph 325B of the Grand Chamber's judgment in BBW. See page 2293, where selectors are applied to the material in order to determine what may be retained for potential examination by an analyst. It is that stage, that selection stage as it were, prior to potential examination, that is the stage to which the European Court applied the strong selectors requirement. They never suggested that the search of a database for information about a particular individual intrinsically required internal authorisation as a precondition to compliance with Article 8. And that reflects the fact that searching a pool of data provided by telecoms operators for CD in relation to an individual is in general terms very much less intrusive than targeting them on an ongoing basis through the application of a strong selector. So there's no proper basis to assume that there will be simply a read across into Part 6, Chapter 2. Part 6, Chapter 3, as you know, concerns bulk equipment interference, or EI, and I made all the submissions I wanted to make yesterday about the nature of that power, backwards looking as it were in its generality, concerning access to stored data, techniques for obtaining it by the use of EI vary and are different from those used in bulk interception. EI can be used to obtain data by the use of evolving search terms that may relate to particular devices or individuals, but in circumstances where the intrusiveness of doing so is not comparable to the intrusiveness of applying strong selectors to communications bearers. And indeed, the practicality of applying a requirement for internal authorization of each of the search terms may be considerably less. And the court may take some interest from, I'm going to give you one reference into the EI Code of Practice. It contains what we submit is at least a relevant example at paragraph 6.5 on page 3762 of the bundle, find tab 78, relating to the use of bulk EI to obtain equipment data from a large number of devices in a specified location. So 3762 is the example, paragraph 6.5, and the example, just to summarise it, to save a bit of time, the example shows EI being used to find members of a terrorist cell in a given location about whom little is known, except that they may use a particular software package. So EI would be used to obtain data from devices in that location, but the ability to refine the data to discover members of the cell would be dependent upon using search terms that would need to alter through the analytical process as common factors relating to the group were discovered. So we submit that there are important differences between those regimes and the one that the European Court was considering in BVW Grand Chamber for this purpose. Part 7, to move to that, the BPD's personal data sets powers, is, we submit, fundamentally different from the other bulk powers anyway, because it does not concern the exercise of any power to obtain information at all. It regulates the retention and examination, as you know, of information obtained under other powers, including often the general powers that are conferred on the security and intelligence agencies under the 1989 Security Service Act and the equivalent act governing or regulating GCHQ and MI6, the Intelligence Services Act of 1994. And there's no basis for saying that the European Court would consider that the same safeguard should apply to data sets obtained without the use of those intrusive surveillance powers under the Act, as to bulk intercept material. Part 7 does provide for the possibility of the Secretary of State making a direction authorising a data set obtained using other surveillance powers under the Act to be treated as BPD. You looked yesterday, as you recall, at section 225, page 2874 in the bundle, but that or any such direction would need to be approved by a JC, by a Judicial Commissioner, under the double lock provisions, and would require consideration of whether regulatory provisions applicable to the original power should continue to apply, as is confirmed by the BPD code, see paragraph 3.7 of the BPD code. For your note, that's at tab 79 of the authorities bundle, page 3849. So if a direction were made authorising a data set obtained under, say, Part 6, Chapter 1 to be treated as BPD under Part 7, the Secretary of State making it and the Judicial Commissioner in approving it would need to consider what regulatory provisions were required by A8, Article 8 of the ECHR, including, where appropriate, the strong selectors requirement.
I'm so sorry, I think I got it done wrong. BPD code, tab 79, 3849, paragraph
3.7.
Thank you so much.
So that's what we say about internal authorisation, set needs for internal authorisation of strong selectors. Next topic in relation to inadequacy of safeguards under ground 2, or alleged inadequacy of safeguards, and the last one before coming next to ground 3. The last one under ground 2 is a response to the claimant's skeleton paragraphs 34 to 38. And this is the point that there is no objective, as I said, no objective and reasonable basis for the differential treatment of content as compared to secondary data, as compared to CD. It is to be noted that this subground has no support whatever from BBW Grand Chamber. It's not one of those things that's said to flow from statements made by the Grand Chamber in BBW that can be applied by analogy in some way, or even directly. It's a simple disagreement with the Divisional Court on an issue on which we submit the Divisional Court was unarguably right. At BBW Grand Chamber states in terms, and I'm quoting from paragraph 416 of BBW Grand Chamber, page 2315, that in the context, as they put it, of bulk interception, the legal provisions governing the treatment of related communications data do not necessarily have to be identical in every respect to those governing the treatment of content. So they're positing that there are a difference and accepting there can in principle be a difference between the safeguarding regimes that apply on the one hand to content, on the other hand to CD. What matters is that the legal provisions for the treatment of each category of material are sufficient in themselves. Also to be noted in relation to the Grand Chamber judgment that they hold in terms that under RIPA it was justifiable for the British Islands safeguard, that particular domestic legal safeguard, not to apply to CD. As illustrative of that distinction, you can have different safeguarding regimes with the CD one being lesser, as it were. See for that purpose paragraph 421 in the BBW Grand Chamber judgment at page 2317. And logically that...
Which paragraph?
It's paragraph 421 in the Grand Chamber's judgment.
My fault, I was writing something else, thank you.
No, I'm sorry. I'm going a bit quick, am I? Yeah. 2317. And logically we submit that conclusion applies equally to the IPA. It must do. All the more so because the safeguards for both content and for CD under Part 6, Chapter 1 are self-evidently much stronger and much more extensive than was the case under Section 8.4 of RIPA. So we submit that nothing in this subground casts any doubt on the reasoning of the judgment of the Divisional Court. I should have given you the reference to their segment of their judgment, but I give it to you now. So this is dealt with in the Divisional Court's ECHR judgment behind tab 30 in the call, in the call bundle, and the relevant paragraphs for present purposes are 171 to 178. You see the reference there in the first sentence of 171 on page 926 to secondary data. This is where you find their reasoning. It's 171 to 178 on pages 926 to 927 of the call bundle. And we submit that the Divisional Court properly and appropriately recognised that the acquisition of secondary data was not necessarily less intrusive than the acquisition of content in all cases, but rightly upheld our argument that as a general rule, the examination of the most sensitive content will raise greater concerns than the examination of secondary data. And that conclusion not only reflects the European Court's case law, I've summarised, given you the references to the BBW Grand Chamber judgment, but it's common sense. In the context of terrorism and other serious crimes, for instance, the content of communications might reveal matters such as the intention, mindset, motivations of a subject of interest, their plans, operational details of their activities, none of which would be apparent from metadata. So there is a proper objective basis for treating them differently. I submit, and the Divisional Court was right, and we are perfectly content to take our stand on those paragraphs in the Divisional Court judgment. As to the claimant's contention that when BPDs are searched for content, no British Islands safeguard applies, that is wrong, we submit. That's about a complaint about BPDs. It's wrong to make that complaint. Where BPDs contain content, that sort of content is protected data, that's the term of art, for the purposes of Part 7 under Section 203 of the IPA, 203 at page 2853, first limb in the argument, as it were. Second limb in the argument, Section 202 at page 2852, provides that an intelligence service may not retain or retain and examine a BPD in reliance on a class BPD warrant if the BPD includes protected data. Third limb of the argument, if protected data is retained under a specific BPD warrant and it is proposed to select it for examination on the basis of criteria referable to an individual known to be in the British Islands, then the Secretary of State may impose conditions in the warrant which must be satisfied before that can be done. See Section 207, page 2857. So the Secretary of State must consider whether some form of British Island safeguard should appropriately apply in the light of the nature of the material. And fourth limb in the legislative provisions in the argument, the Secretary of State must ensure that those conditions are met when selection for examination is effected. Three further short points following on from that in relation to this. Firstly, BBW Grand Chamber did not suggest that the British Island safeguard was required for compliance in any case, placing much more weight on the requirement for internal authorisation of the strong selectors. See for that purpose paragraph 421 of their judgment. Secondly, I've made the point already, the nature of BPDs anyway is not generally analogous to the nature of bulk intercept under Part 6, Chapter 1. Part 6, Chapter 1 is a foreign intelligence focused power. The main purpose of the warrant under that chapter and that part must be the interception of overseas related communications and related communications data. See Section 136 of the Act at page 2791. The fact that Part 6, Chapter 1 concerns foreign intelligence is, we submit, an important part of the context for the British Islands safeguard. It explains why the safeguard is workable, because the use of the power to obtain information about persons in the British Islands will be at least comparatively rare. It also explains why the safeguard may be appropriate to ensure that the bulk power is not used where targeted powers could be used instead, as will usually be the case where persons are indeed in the British Islands. So those are differences, important differences of context. By contrast, this is the third point, Part 7 deals with data of different types that may be acquired from a whole variety of different sources and by different methods. See, for example, and as illustrative of that proposition, paragraph 4.31 of the BPD Code at page 3859. So we submit that there's nothing in the points about the British Islands safeguard, and there's nothing in the points about the differential way in which the new Act is set up as between content and secondary data. Indeed, that fundamental distinction under the new Act, introducing in effect three categories, content, secondary data and CD, simply reflects a legislative choice, and it might be thought that that is in Strasbourg and safeguarding terms a virtue, not a vice, because what it does is to recognise that there may be, as it were, nuances in relation to the type of information or the type of data that you're dealing with, and that different provisions might need to be made as a matter of legislative choice as to how you go about doing that. Now, of course, these things are never porous, and when you try and draw dividing lines in legislation between things as complex as that, you're always going to end up with marginal distinctions, as it were, on the boundaries. But in principle, that is a perfectly legitimate and sensible thing for Parliament to have tried to grapple with and to have done. One bears in mind the contrast to the previous position in relation to RIPA, where content wasn't defined at all. CD was defined in relatively narrow terms, and it followed that anything that wasn't within the definition of CD under RIPA as relatively narrowly defined automatically became content and attracted all the protections that applied to content. So what Parliament has evidently done is to think, I want to make it more sophisticated than that. There may be some bits of the metadata that ought to be treated as secondary data rather than content, and I'm going to introduce these categories. But what Strasbourg says in BBW Grand Chamber doesn't touch that at all. That's just a matter of legislative choice. As I said at the beginning, there is at least a real virtue in trying to draw distinctions more finely for these purposes rather than less. So that's what we say about that distinction between content, secondary data, and CD. I turn to ground 3, which is the absence of safeguards when sharing material with overseas authorities. This ground relies on a BBW Grand Chamber, as you will recall, where Mr. Jaffe was dealing with it in opening. It relies on BBW Grand Chamber paragraph 362 at page 2302, which sets out, maybe worth just reminding yourself by way of background to what it said about all of that. It sets out safeguards for the transmission of bulk intercept material overseas. So 2302, if you have the BBW Grand Chamber to hand, and you'll recall, I'm sure, paragraph 362. And it's said by Mr. Jaffe that none of parts 5, 6 and 7 of the IPA contains the safeguards to which 362 refers. And we submit that there are two basic defects with that. Firstly, the relevant legal principles in BBW Grand Chamber were specifically and explicitly concerned with the transmission of bulk intercept material to overseas states, not the transition of intelligence material generally. See for that purpose paragraph 362 itself and the points already made about the fact-sensitive nature of the judgment that Strasbourg was producing. Secondly, and in any event, we submit that it is important to recognise that the European Court held that the provisions of the Section 8.4 regime for sharing intercept material with other states was compatible with ECHR rights. So 362 has to be read with what they did when they got to the facts and the context even of RIPA, and they dealt with that question at paragraphs 395 to 399, starting at page 2310. So 395 to 399 is where they deal with that. And here our submission is that the relevant provisions of the IPA, our new act as it were, and the codes in relation to that, in relation to all the relevant powers, contain either strengthened or at least materially equivalent protections by comparison to those under Section 8.4 of RIPA. So the provisions for sharing intelligence under the IPA are, if you will, a fortiori. We'll deal first with bulk intercept. Under the Section 8.4 regime, as you will recall, of RIPA, disclosure overseas was addressed in, I don't invite you to turn these up now, but just for your note, it was addressed in sections 15, sub 2 to 3 and sub 7. If you want those provisions of RIPA, they're at page 3213 in the bundle. and were also addressed at paragraph 7.3 to 7.5 of the RIPA, the old RIPA Interception Code, which in its last edition from 2016 you have in the bundles behind tab 81 at page 4015. Just to summarise, sections 15, 2 and 3 of RIPA require that intercept material is copied and disclosed to the minimum extent necessary for the authorised purposes and destroyed when no longer necessary. It's that set of provisions to do with storage and destruction. And section 15.7 provided that the requirements corresponding to those in 15.2 should apply, quote, this is under RIPA, to such extent, if any, as the Secretary of State thinks fit. That was in RIPA, when material is disclosed to overseas authorities. And by section 7.5 of the RIPA Code, where intercepted material is disclosed to a foreign state, the security and intelligence agencies must take, quote, reasonable steps to ensure that the authorities have procedures necessary to safeguard the intercepted material and to ensure that it is disclosed, copied, distributed and retained to the minimum extent necessary. That includes that the material must not be disclosed to a third country, i.e. bouncing on from, say, America to Guatemala, unless explicitly agreed, and must be returned or destroyed when no longer necessary. So that was the position under RIPA. Under the IPA, sections 151 and section 150 sub 2 and sub 5, page 2803 in the bundle will get you roughly into that set of sections. They are of equivalent effect. Sections 15.2 and 3 and 7, so sections 15 sub 2, sub 3 and sub 7 of RIPA. And that is because, self-evidently, because section 150 of the IPA, sub 2 and sub 5 mirror sections 15, 2 and 3 of RIPA.
What did you say, section 50?
Subsection 150 sub 2 and sub 5 of RIPA, of the IPA, they mirror sections 15 sub 2 and sub 3 of RIPA. And those provisions of the IPA, in other words, section 150 sub 2 and sub 5, are disapplied in the case of disclosures to foreign states by sub 7 and sub 8 of that section, that's 150. But section 151 of the IPA provides that requirements corresponding to those in 150 sub 2 and sub 5 should apply to overseas disclosures to such extent, if any, as the Secretary of State thinks appropriate. And that's materially indistinguishable from the statutory test that used to apply under section 15 sub 7 of RIPA, whose language I gave you earlier on. There is then the current interception code, which you looked at yesterday, behind tab 90, and there's a key section which includes, as you recall, looking at paragraphs 9.28 to 9.29, but also includes earlier paragraphs which refer back itself to earlier paragraphs in the code, explaining how the Secretary of State should approach the task of determining what safeguards it will be appropriate for the foreign state to apply. And what the new guidance does, what the new code does, is to acknowledge that this is a matter for the Secretary of State to consider. And so it sets out or helps with an approach to that issue, judging appropriateness. Not surprising that the new code does not purport exhaustively to cater for all cases. And of course, arrangements with a foreign state are to be judged when made. But what happens is that there is a regulation of the exercise of the Secretary of State's discretion under the code, rather more tightly in some respects than the RIPA code, explaining that countries with whom the SIAs customarily share intelligence apply equivalent safeguards, but where intelligence has got to be shared with a country with whom we don't have such a strong or existing intelligence relationship, the Secretary of State has got to apply a test which balances the risk of less stringent safeguards against the risk to national security of not sharing information. But of course, all that does is to acknowledge that there is a discretion to be exercised, that careful consideration needs to be given to these issues, and of course, see the cases I took you to yesterday in relation to Section 6 of the HRA. Section 6 of the HRA applies. And now, of course, BBW at Grand Chamber. So we respectfully submit that there is nothing to suggest that having decided what it decided in relation to the old RIPA code and the old RIPA provisions, and those legislative provisions that I've indicated were in materially identical form to those that currently exist under the IPA, including the complaint about those provisions that my learned friend sought to make, which was that you've conferred a discretion and you made it so open-ended it's meaningless. That point, that was exactly replicated in Section 15.7 of the European Court of Human Rights in BBW, nevertheless cleared that. So there's nothing in BBW we respectfully submit to suggest that having found that the RIPA setup was good enough for this purpose, they would suddenly find that the IPA position is not good enough.
Those are the words as appropriate.
They're as appropriate, which feature in, to such extent, if any, as the Secretary of State thinks fit. And the only difference is it now says to such extent, if any, as the Secretary of State thinks appropriate. So slightly more modern language, but the essence is the same. That's between 15.7 and Section 151 of the IPA. So that's in relation to bulk interception. The position in relation to the sharing with overseas authorities under Part 5 and Part 6, Chapters 2 and 3, is materially identical to the position in relation to bulk interception. That leaves only BPDs, therefore, under Part 7. And on that, the claimant is wrong to say, as they do, that there is, as they put it, no provision at all in relation to the sharing of information with overseas authorities in relation to BPD. The position in relation to that is as follows. The agencies have given public assurances about the safeguards that would apply if BPDs were to be transmitted to foreign partners. They are contained or were contained in a witness statement for the purpose of the IPT proceedings in Privacy International against the Secretary of State for Foreign and Commonwealth Affairs. The IPT's judgment recorded that, their judgment of the 23rd of July 2018 at paragraph 62, and you find that, if you want it, behind tab 89 in the authorities bundle at page 4279 to 4280. And they're detailed and prescriptive. The IPT held, in that case, in the light of that statement, that the arrangements for sharing of BPD under the previous regime were in accordance with law under Article 8, see paragraph 71 of their judgment at page 4285, and that statement continues to apply. And nothing, we respectfully submit, in BBW Grand Chamber suggests that those publicly avowed principles in relation to overseas sharing of BPD would not satisfy Article 8. You'll also note that the applicable regime for sharing information now includes Section 109 of the Data Protection Act 2018, Bundle of Authorities, tab 69, page 3267, and that relates both to BPDs and other information under other parts of the IPA, and it contains a statutory requirement that any transfer be necessary and proportionate for the SIA's statutory purposes. So that's what we say about ground 3, absence of safeguards when sharing material with overseas authorities. Ground 4...
Is there any Strasbourg authority that says a public assurance in a witness statement satisfies the in accordance with law. There's lots of things about codes of practice and so on. Is there any Strasbourg authority, or is it just the IPT? I assume it's the IPT, given that's what you referred to.
It's the IPT seeking to apply the pretty broad approach that Strasbourg takes to that. I mean, you'll be aware that in Luxembourg there's a set of issues around whether or not law means the same thing.
Yeah.
But certainly for Strasbourg purposes, if there had been public assurances, a public commitment that would operate in terms of law, there have been lots of challenges on that basis in front of the IPT, and they've always consistently held that is enough for present purposes.
Right. Okay.
And they do so in this case. We submit that that's right. Not aware of a direct Strasbourg authority precisely on point. I'm sure we could find something in which that's been taken into account by Strasbourg, but that's my submission at least. Ground 4, if I may, impermissibly broad BPD's regime. This is this was the subject of submissions, helpful submissions by Mr. Heaton yesterday, and in response to it, we note first of all that this ground of challenge is again unrelated to the conclusions in BBW Grand Chamber. It is a simple disagreement with the Divisional Court's conclusions and reasoning in their ECHR judgment. And again, we take our stand and are prepared to take our stand perfectly contentedly on those paragraphs in that ECHR judgment. The relevant paragraphs dealing with this challenge are at paragraphs 210 to 240 of the DC's ECHR judgment, core bundle 934 and following, page 934 and following. And just by way of brief summary, we submit that the ground now advanced misunderstands what Part 7 actually does. Contrary to their skeleton of paragraph 47, Part 7 does not capture, their word, any information at all. It provides a comprehensive system of safeguards for the retention and handling of BPDs acquired under other powers, most materially using the agency's general powers to obtain information under the 1989 and 1994 Acts. It isn't therefore a weakness, but rather an obvious strength of Part 7, that it applies to BPDs of all types, including BPDs which contain content, health records, or other types of sensitive information. It means that all kinds of information within BPDs benefit from the protection of warrants requiring JC, Judicial Commissioner, approval, and from other safeguards within the Part 7 regime, including for sensitive categories of information. So, in respect of BPDs, we submit that Part 7 provides exactly what S and MARPA required. That is, clear, detailed rules and minimum safeguards governing the retention, use and destruction of information. Mr. Jaffe stressed that BPDs could include, for example, health records. But we'd invite you to note that the whole way in which the Part 7 regime operates is that the more sensitive the type of data within a BPD, the more the safeguards that are applied to it. That's the basic structure of Part 7. So to take health records as an example, health records will contain, quote, protected data for the purposes of section 203 of the IPA, page 2853. So they would require a specific BPD warrant, not a class warrant. Then section 206, page 2856, sets out special protections for health records that it is sought to retain or examine under a specific BPD warrant. The Secretary of State must consider that there are exceptional or compelling reasons to justify retaining and examining them. Exceptional or compelling reasons. And that conclusion will then be reviewed by a Judicial Commissioner under the double lock. So the way in which health records are treated is just an example of the general purpose of Part 7, to provide a statutory scheme tailored to the particular sensitivity of the type of information within the particular BPD. And none of those safeguards previously existed at all. The claimant's complaint about what they describe as a lack of safeguards in Part 7 is principally contained in their skeleton at paragraph 48. Call bundle page 56, claimant skeleton, paragraph 48, and just a couple of responsive points, if I may, to each of the sub-paragraphs within that paragraph. 48 Roman 1 is wrong. Part 7 does contain mandatory requirements for deletion of BPDs. BPDs can only be retained at all pursuant to a warrant, subject to the temporary bridging power addressed by the Divisional Court in their ECHR judgment at paragraph 237. If a warrant ceases to have effect, the BPDs must then be deleted. That position is inherent in the entire scheme of Part 7. See, in particular, section 200, sub 1 of the IPA at page 2851. It says an intelligence service may not exercise a power to retain a bulk personal data set unless the retention of the data set is authorised by a warrant under this part. That's section 200, sub 1, at page 2851. Moreover, the BPD code, still on the criticism of 48.1 of the claimant's skeleton, the BPD code provides at paragraphs 7.53 to 7.56 behind tab 79, page 3898, that each agency must regularly review the operational and legal justification for its continued retention of each BPD retained under a class warrant at intervals agreed with the Secretary of State, and using a process which is then set out in detail in that code at paragraphs 7.53 to 7.53. And where the continued retention of any data within the BPD no longer meets the tests of necessity and proportionality, all copies, extracts and summaries of it held within the agencies must be scheduled for destruction as soon as no longer needed for any authorised purpose. See paragraph 7.55 of the code. And the retention of any BPD should be subject to scrutiny under an effective system to ensure, among other things, that its retention remains necessary for the specified operational purposes. See paragraph 7.56. So that's 48 Roman 1 of the skeleton. 48 Roman 2 is wrong. The BPD code contains mandatory requirements to minimise the disclosure and copying of information in BPDs, which are supplemented by the general provisions regulating disclosure of information in section 2.2a of the Security Service Act and the equivalent provisions in the Intelligence Services Act. For instance, see for that purpose the following paragraphs of the code, which I'll give you and then very briefly summarise: 7.5, 7.9 and 7.50 to 7.52 of the code. Tab 79, page 3886 will get you to the first of those. That if individuals, the summary of the position is that if individuals access a BPD with a view to its subsequent disclosure, they may only do so if such disclosure is necessary for the agency's statutory functions. Before disclosing information from a BPD, the individual must consider proportionality, applying the detailed approach which is described earlier in the code at paragraphs 5.21 to 5.24. The number of results presented for analysis from a BPD must be minimised, by requiring queries to be framed in a proportionate way, and if necessary, confining access to specific data sets or subsets of them to a limited number of analysts. And disclosure of BPDs continues to be regulated by the minimum disclosure provisions that I identified, Section 2.2a in the Security Service Act and its equivalent analogue provisions in the Intelligence Services Act. And they impose a duty on the agencies, or the heads of those agencies, to ensure that there are arrangements in place to ensure that no information is disclosed by them except so far as necessary for their functions or for the additional limited purposes defined in those subsections. So that's 48 Roman 2. 48 Roman 3 is also wrong. It is inaccurate to say that no British Islands safeguard applies to BPDs. I've already covered that, as already explained. Appropriate safeguards for protecting information of persons believed to be in the British Islands apply, albeit for good reasons. They may not be identical to those in Part 6, Chapter 1. I dealt with that already. And for the same reasons that I've also dealt with in relation to sharing with foreign partners, 48 Roman 4 is also wrong. So that's what we say about ground 4. Ground 5 is the absence of adequate safeguards for lawyer-client communications. That's dealt with in the claimant's skeleton at paragraphs 53 to 55, and was again the subject of some brief and helpful submissions by Mr. Heaton yesterday. It is in response to this ground worth at least recalling what the protections actually are. The protection provided by Section 2 of the IPA includes, by Section 2(1)H, approval of the use of criteria for examining LPP material under the bulk powers, so under Section 153, bulk interception, under Section 194, bulk EI, and under Section 222, protected data retained under a specific BPD warrant. So public authorities, including the agencies, must consider whether the level of protection to be applied is higher because of the particular sensitivity of the information, see Section 2.2b, and by Section 2.2d, any other aspects of the public interest in the protection of privacy. Also to be noted that the duties under Section 2.2 generally are subject to the need to have regard to other considerations, including necessity, proportionality, and the requirements of the HRA. See for that purpose Section 2 sub 4. Also to be noted before one gets to the specific provisions governing LPP, that before you get anywhere near examination of any material, you have all of the safeguards built in by the rules and provisions applicable in the IPA to selection for examination anyway. Operational purposes, JC approval, the fact that it's national security and overseas focused anyway, the code requiring analysts, that analysts set out why things are considered necessary and proportionate to be selected for examination and then examined, with all of the capacity that that sort of records creates for audit and oversight by IPCO. And see on the latter point, audit and oversight by IPCO, see the code, Chapter 6, behind the interception code at Chapter 6, paragraphs 6.17, 6.59, 6.70 and 6.73, all of which are to be found behind tab 90 at roughly page 4406.
617, 659, 670 and
673.
thank you.
For bulk intercept then and bulk EI, there are three safeguards in effect in section 153 of the Act, 153 of the Act. One a need for senior officer approval where the purpose of selection for examination is the identification of LPP content, or that is likely, see section 1531. The senior official can only give approval where he or she is satisfied that there are specific arrangements for the handling, retention, use and destruction of LPP material, see section 153 sub 4a. And if the purpose is to identify LPP material, there are compelling and exceptional circumstances justifying that, see section 153 sub 4b. Page 1200, I'm grateful.
Which section?
1534b.
Thank you.
And where the purpose is to identify LPP material, the official must also have regard to the public interest in confidentiality of items subject to LPP. See section 153 sub 3. That's the first of the safeguards in 153. The second of the safeguards is that you also need senior official approval where an item is to be selected for examination, which would be covered by LPP if it isn't made with the intention of furthering a criminal purpose. That's section 156 sub 6 to sub 8. And third safeguard, there's then a requirement to notify IPCO if an item subject to LPP has been retained, and IPCO can then impose conditions or orders of destruction. And of course, IPCO has a general oversight and auditing function anyway. So this ground is really an attempt to draw some still broader principle from the journalistic material requirements in BBW Grand Chamber. And as an initial reminder, they do not extend as far as the claimants contend, even in relation to journalistic material, for all the reasons I went through earlier when dealing with that under ground 1. The ground is not only a disagreement in effect with the Divisional Court's ECHR judgment, it cuts across arguments considered by or in the BBW Grand Chamber proceedings. They did have submissions, that I think is common ground between us, both from the Law Society and from the International Commission of Jurists, that special protections were required for lawyer-client communications. See the summary of those submissions in the Grand Chamber's judgment at paragraphs 320 and 321. That gave them plenty of opportunity to find, if they wanted to do so, that the Convention required this, in other words, prior independent authorisation. They plainly chose not to do so. So there is no basis, we submit, within the Grand Chamber's judgment for impugning the Divisional Court's careful analysis, and I should have given you the paragraphs earlier, but the key paragraphs in the Divisional Court judgment on this aspect are in their ECHR judgment at paragraphs 271 to 292, that whole section deals with this, core bundle, page 945 and following. And none of the case law from Strasbourg, which predates BBW Grand Chamber, and some of which appears and was evidently considered, therefore, by the Grand Chamber in BBW, Szabo, Telegraph Media and so on, are cited, but none of that earlier case law goes further than the general principle that the extent of safeguards required will depend upon the level of interference with convention rights. Nor, it might be thought, could it go further to establish particular rules for privileged communications when the scope of LPP evidently differs, and may differ quite markedly, as between different contracting states' legal systems, as we know. But the authority for that general principle is RE against the United Kingdom, which is behind tab 47 of the authorities bundle at page 1694. Just invite you to turn that up briefly if you would. So tab 47, 1694, which I hope should get you to paragraph 130.
We looked at this previously.
Yes, 130 and 131. To go back to it unnecessarily if you have it. Can I just invite you to note that the reference to 130 is there's a mistaken reference in our skeleton, paragraph 67, which gives this relevant reference into the RE case as being to 118. It should be to 130. So just note that difference. But RE was about targeted surveillance of lawyer-client communications at a police station pursuant to an authorisation for intrusive surveillance under Part 2 of RIPA, and the European Court said that the surveillance entailed a very high degree of intrusion, held that in the circumstances the provisions of Part 2 of RIPA and the relevant code didn't comply with Article 8, and that was because they didn't contain safeguards for examination, use, handling of the material obtained equivalent to those provided for targeted intercept under Part 1 of RIPA. By contrast, those safeguards in Part 1 of RIPA had already been found to be compatible with Article 8 by the European Court in its Kennedy and the United Kingdom judgment. I don't invite you to turn it up now, but for your note, that's behind tab 39 at page 1369. And those safeguards in Part 1 of RIPA did not include any requirement for independent authorisation or indeed in terms for an overriding public interest on the face of the legislation before communications were intercepted or viewed or retained. So that reasoning is directly contrary. It was simply based in RE on equivalence with an earlier set of legislative provisions in Part 1 of RIPA, which themselves had been cleared, even though they didn't do what the claimants now assert they needed to do. So that's authority directly contrary to the suggestion that independent authorisation is required because these were lawyer-client communications. Mr. Jaffe complained yesterday that the requirements, or the day before, that the requirements in section 153 didn't apply to secondary data, but only to content. And he said, we've had this debate uphill and down dale in previous iterations of these proceedings, he said that secondary data / CD could still be subject under English law to the protection of LPP. But the question under the Strasbourg setup and jurisprudence is not what domestic law might or might not cover, but what the sensitivity of the material is. Secondary data, even if legally privileged at all in certain circumstances, certain pretty narrow circumstances, will not be sensitive in relation to the prime rationale for LPP, particularly when that concept is considered on a contracting state-wide basis. And it won't be of that ilk, because what LPP fundamentally and in its essence protects is the confidentiality of what lawyers say to their clients and vice versa. And so we respectfully submit that's the answer to that complaint. And there's nothing in any Strasbourg case or authority to suggest that the protection needs to be applied not just to content, i.e. the core and essence of that protection, but to CD or secondary data. We set out in our skeleton at paragraph 68 why it is that we say that none of the European Court authorities cited by the claimants is on point or really advances their argument that independent authorisation is required, and perhaps rather than trawling through those cases at breakneck speed, can I just focus on one of them, which was COP and Switzerland, on which my learned friend Mr. Heaton placed some reliance. COP and Switzerland is behind tab 28 at page 1056. And the core point about this is to bear in mind that this is a case which turned on its own specific and pretty extreme looking facts. So it's tab 28, got the split between the bundles, I'm afraid, but tab 28, page 1056.
Got it now.
Thank you, I'm sorry.
No shortage of bundles.
No shortage of bundles.
Yeah.
So this was a case about tapping the private and professional telephone lines of a lawyer who was under criminal investigation, but its key point is it's super fact sensitive. The essential facts are those set out in the Commission's decision at page 1062. By the Court's decision. So paragraphs. Which one? Commission and Court. So you see the facts from paragraph 18 on page 1062, 15 to 18. Can I just invite you to cast an eye down those paragraphs? The federal prosecutor orders the monitoring of Kay's telephone lines as a third party in an investigation to discover the source of leaks of official secrets. You can see at paragraph 18 that some 13 telephone lines were monitored over a number of weeks, and they included both personal and professional phone lines, and post office officials listened to all the conversations from the offices of the lawyer's firm over a 3-week period. So they listened to a huge array of no doubt privileged or large part privileged information. And one can see from paragraph 69 on page 1071
1071.
That's the Commission, so.
Paragraph?
Yeah, sorry, this is in the Commission's decision. You see that from the bold thing, but I'm just going to it for the facts. Paragraph 69 on page 1071. That the people who decided which conversations were privileged and should be disregarded under the relevant systems of law in Switzerland and which were not were staff of the Postal Service. It was in that context that the European Court said in the judgment at paragraph 74, skip from the Commission into the Court, go forward to page 1082, takes you back into the Court's reasoning with the non-bold paragraph numbers. Look at paragraph 74 on 1082. It's in that context that they said in the judgment that it was extraordinary that the decision of what was and what wasn't LBP should have been delegated to an official of the Post Office without independent supervision. So the point that exercised the court in truth in this case, in context, was that in that context the distinction between privileged professional conversations and other matters was being assessed by Post Office officials without any supervision from a judge. One can see why that might be regarded as slightly problematic from any sort of perspective. So the Divisional Court, we respectfully submit, rightly said that this case, particularly now you see the extremity of the facts and what was truly lying at the heart of the court's concern in Strasbourg, did not, said the Divisional Court, purport to lay down any general principle that any decision whether to examine materials subject to LPP should be supervised, let alone authorised ex ante by a judge. See for that purpose the Divisional Court's ECHR judgment at paragraph 288, core bundle, page 947. Of course, if Prop is a pretty early case in terms of the date, it's 1990, if it had laid down any principle of that general kind of independent authorisation ex ante requirement for LPP material, then the European Court would not and could not have reasoned as it did in the RE case that I turned up earlier, which was October 2015, and there are any number of other subsequent cases that have indicated that independent ex-ante authorisation is not required just because you're looking for lawyers' communications. Can I turn up one other case, which is behind tab 41, a case called Haino, and I want paragraphs 44 and 45 on page 1472 of the bundle. It's really paragraph 45, first sentence makes the point, where the court expressly says that you need either ex-ante authorisation or the possibility of ex-post judicial review. Exactly the type of oversight that the IPT has been providing and has been set up to provide, and indeed has been found by Strasbourg to provide in Kennedy and the UK and in BBW Grand Chamber.
Sorry, which paragraph are you looking at?
It's paragraph 45, really.
Thank you so much. 44
and 45 together, but the key is in the first sentence of 45, giving those alternatives, so making clear there isn't some general rule that you always need ex ante. A couple of final points, if I may, on LPP. Just a note that lawyer-client communications are, of course, subject to the general privacy duty in section 2 as well, which I referred you to earlier, and that specifically refers to items subject to legal privilege as examples of, quote, sensitive information where public authorities are required to have regard to whether the level of protection that should be applied is higher. That's page 1041, section 2 of the IPA. And that answers the claimant's point at their skeleton paragraph 55.3 that the BCD regime makes no provision in relation to lawyer-client communications. Just a note in that context as well that the BCD code, paragraphs 6.19 to 6.23, behind tab 80, page 3943, refers to the examination of CD relating to sensitive professions, including lawyers, as requiring special care to be given regarding selection for examination, including additional consideration of whether there might be unintended consequences of such examination and whether the public interest is best served by selecting it for examination. Of course, communications data is incapable in any event of revealing the substance of any legal advice or even its subject matter. And so we do submit that as the Divisional Court in their ECHR judgment at 282, para 282 and para 290 to 291, so 282, 290 to 291 of the Divisional Court's ECHR judgment, call bundle 947, as they concluded there are accordingly adequate safeguards for lawyers' communications data.
You just mentioned communications data can't be read. I thought we were in, hang on, bulk interference and equipment. We've moved on from that, have we?
We have.
Right, okay. Well, okay, don't worry.
So we're just on CD and that conclusion and the...
Oh, yes, you have, sorry.
Yeah.
It's my notes. I haven't got the heading in. Sorry. I beg your pardon.
And second final point in this, in relation to the structure of the IPA, there was some criticism of the fact that there was nothing equivalent in the bulk acquisition provisions. But again, that's about CD. See section 158 sub 6. So I'm just covering that off and the points are the same, effectively. That's all I want to say about the ECHR grounds. Can I turn to the EU law grounds? I can take, I think, a bit more The claimant's appeal on European law has three aspects. They contend, firstly, that contrary to the findings of the 2008 Divisional Court judgment behind 2018, I'm so sorry.
I know it feels like the case has been going on for a long time. We're not quite that long.
2018 behind tab 29 of the core bundle, and their 2022 judgment behind tab 31. The claimants say that contrary to the findings of the Divisional Court in both of those judgments, parts 3, 4, 5, 6 and 7 are all provisions making provision for, quote, general and indiscriminate retention of and access to data within the meaning of retained EU law, and yet they lack the safeguards as the essential allegation that retained EU law requires. That's the first criticism. The second is that the Divisional Court erred in holding that there is a prior independent authorisation of access to data retained under the bulk powers, because while a bulk Part 5 thematic warrant is initially authorised by a judicial commissioner, retained EU law in effect requires the authorisation of each particular access request, meaning selection for examination. That's the second criticism.
So hang on, even if you've got one authorisation to cover the initial collection and examination,
you need,
if you go and look at it the next week again for a second time, you need a further one the next time you look at it.
Or if it's more specific than the operational purposes and the the original warrant, exactly. But it's at that stage, so that's the criticism. So the EU law has got a general principle that requires it.
Yeah.
That should be done by way of JC or independent authorisation.
Yeah.
And thirdly, they say that the Divisional Court should have held that the IPA breaches the requirements of Articles 7 and 11 of the EU Charter, and that's essentially a piggybacking on the findings of what they assert to be the findings of BBW Grand Chamber. I'll come to that as the third aspect. General and indiscriminate, therefore, first. My learned friend Mr. Jaffe was at pains to soothe the court, if that's the right way of putting it, by explaining that he was really, this really wasn't an area to be terribly excited about, because it just related to a narrow group of safeguards, particularly those found at 181 of Quadrature, and it might only require a small tweak, so don't worry too much about all of this. The difficulty, of course, with that is that the sting of the argument, or the potential big sting of the argument, is that if data is categorised or characterised in this way as being general and indiscriminate, the logic of the Luxembourg judgments, as acknowledged specifically by the Divisional Court, and I'll give you references in a second, if it is G&I, if it is general and indiscriminate, the logic of those judgments is that you can't acquire any of that data for the purpose, or for only very limited acquisition is possible, for the purpose of criminal investigations. So it isn't just about a little tweak to the safeguards, this is about whether or not you can do it at all, or across the range in relation to criminal investigations. So the Divisional Court recognised that as a matter of true significance, and providing the essential context of the debate that then followed, see, for that purpose, for them recognising that fact, paragraph 118 of their 2018 judgment, 118 of their 2018, one at core bundle page 876, and also see the same point reflected in their quotation of Quadrature at paragraph 50 of their 2022 judgment. Same point. The claimant's essential point is that the Luxembourg court has treated bulk powers as meaning or equaling general and indiscriminate. and we submit that simply isn't correct. It's clear and obvious, we submit, just as a matter of ordinary language, that a legislative scheme that makes provision in some circumstances for comprehensive obtaining of comms data in bulk is not synonymous with a scheme that is general in nature, let alone indiscriminate. And the argument to the contrary mounted by the claimants was and has been firmly rejected by the Divisional Court in both of the two attempts to persuade it otherwise. See, for that purpose, the careful and we submit respectfully correct reasoning by reference to the details and the structure of the of Part 4 of the Act in the 2018 judgment at paragraphs 127 to 137, core bundle page 878. And the point was rejected again in relation to other aspects of the Act in the 2022 Divisional Court judgment at paragraphs 39 to 40, and in particular 108 to 117, and then 140 in relation to different parts of the Act. That's in the core bundle.
108 to 117.
108 to 117 and then 140. 140 deals with BPD in Part 7. And that's in the core bundle, tab 31. Lots of different page numbers, but 1010 will get you to the first of them. And they did that because in both of those judgments, they set out the range of factors and controls in each part of the Act. Necessity, proportionality, operational purposes, all of that. All of their ECHR points. They set out all of those factors and controls in relation to each part of the Act. I'm not going to go back over the detail and the summary. You've had all of that already, but it is absolutely clear, we submit, that there is no sense in which the Act requires the blanket or any retention of data, or even permits general and indiscriminate retention to occur. And it is worth standing back, as it were, it is worth examining the way in which the CJEU has used and applied that terminology of general and indiscriminate, which we've summarised from the three cases of Watson, Privacy and Quadrature, which are behind tabs 15, 17 and 18 of the authorities bundle. We've summarised the position in our skeleton at paragraph 79, I can take it from there. The CJEU has used the phrase as a descriptor for legal regimes which share key features with each other, but which differ radically from the scheme set out in the Act. Notably, they each essentially required or permitted the imposition on communication services providers, or CSPs, of a blanket retention obligation. So in Privacy International, for example, Mr. Jaffe highlighted paragraph 69, tab 17, page 645 of Privacy, as the answer to question 2, but it's important to read it with paragraph 68, the CJU's summary of proportionality, the absence of that safeguard being condemned in relation to the Telecommunications Act of 1984. And so this was also, that they were dealing with that species of legislation that's markedly different from the IPA. That was the core conclusion of the Divisional Court. See their 2018 judgment, paragraph 121, and their 2022 judgment in the paragraphs I've given you already, 106, 117 and 140. And it's notable that the Court of Appeal, in its judgment, may just be worth turning that up, tab 9, at page 360 of the authorities. This is Lord Lloyd Jones. So it might be, is it tab 9 of the court? Tab 9 of the authorities. This this is the Court of Appeals judgment in Watson, where they describe the Swedish legislation in the terms that you see at paragraph 26.2 towards the bottom of page 360. So they describe the Swedish legislation that was considered in Watson as imposing a requirement of blanket retention of all communications data by all communication services providers, and specifically rejected a submission that the CJU's conclusions in relation to the Swedish legislation could be read across to DRIPA, which was of course the IPA's predecessor. And see also now, for present purposes, the Luxembourg Court's summary of its own case law in GD. That's at tab 20 of the authorities bundle, page 856. Should get you, I hope, to paragraph 66. So tab 20, page 856, paragraph 66. And you see their description in the first sentence of 66. General indiscriminate retention of traffic indication data is covering the electronic communications of practically the entire population without any differentiation, limitation or exception being made in the light of the objective pursued. Such legislation is comprehensive and it affects all citizens using electronic and so on and so on. So we submit that the core error that we respectfully submit the claimants fall into, including in relation to its challenges to the reasoning of the Divisional Court in 2022 and 2018, is to, in effect, to equate bulk retention with general and indiscriminate. That's plainly not how the CJU has approached matters. They've never conflated bulk powers with general and indiscriminate powers, otherwise all that analysis would be irrelevant. Blanket. And the fact that the operation of the restrictions and the safeguards in our Act may in practice result in the wide retention of data, Mr. Jaffe's, whether it was correctly attributed to me or not, I can't remember, but the haystack point, that is, if a haystack is gleaned, then that is the product of the application of those safeguards, and it's because it's necessary and proportionate for a haystack of that size to be taken.
Because there may be more than one haystack.
Because there may be more than one haystack, exactly. Not just blanket, as you say.
The bulk would be all right under ECHR, but never all right under EU law, or retained EU law on that analysis, on their analysis.
Yes. Which is itself quite a surprising proposition, particularly given the generality of it. Just back to that haystack, as my Lord, I think Lord Justice Lewis observed, it's not going for a particular haystack, it's going for every piece of straw out there. It's that's the distinction, effectively. We do submit two final short points in relation to this, before coming to the the more technical part 7 issue, as it's called. The two final points in relation to general and indiscriminate. The first point is that if all that he's aiming at, and we know now that it isn't all that he's aiming at, because it cuts out a vast swathe of use for criminal purposes, which is utterly essential, but even if it was all that one was aiming at, and if all he's after is the requirements in 181 of quadrature, you remember those, the kind of discrimination, you can't do it on racial profiling grounds, if that's all he's aiming at, then he's got a problem anyway, because collection is plainly not based on any of those. It is by definition more general than that. I mean, you're never going to do it on that basis. And more fundamentally, perhaps, if the answer to that is the one that he gave, which is, well, you can't collect unless you've got the examination stuff sorted out correctly. The difficulty with that is it's hard to see how, at the examination stage, it could be said that those particular features identified in 181 of quadrature needed to be put on the face of a legislative scheme which already contains all of the safeguards that you see in relation to the Act. So impossible to see how at the examination stage, selection alone of those types of discriminatory criteria would ever pass muster, would ever to pass the Judicial Commissioner, even if they ever pass the Secretary of State, as being necessary, proportionate and compatible with Section 6 of the HRA. And that was, we note, the 2022 Divisional Court view. See paragraphs 117 to 119 of their 2022 judgment for that purpose. And final point in relation to this is really a for completeness point. The attempt to draw a comparison between the skeletal provisions of Section 94 of the Telecommunications Act, 1984, and privacy CJEU are clearly in act. We've dealt with that in our skeleton at paragraph 85. That provision under 94 could indeed be exercised by the Secretary of State to create pretty much the same position that inured under the Swedish legislation considered in Watson. But that is not possible on any view under the Act. There is a Part 7 issue here, which I think I ought to deal with, if only briefly. The Part 7 issue is raised by the claimant in their skeleton at paragraphs 85 to 86. And it's really whether or not the Divisional Court was correct to hold in their 2022 judgment at paragraph 139, so 2022 judgment 139, Core Bundle tab 31, page 1029, that Part 7 of the Act does not fall within the scope of retained EU law at all. We've dealt with that in our skeleton at paragraphs 91 to 93, and as appears to be accepted, and if not accepted, it's clear from the face of the legislation, Part 7 does not contain any power to acquire information, still less to impose a duty on CSPs to provide information to the state. It concerns instead, as I've already noted, how the agency must handle BPDs that have already been obtained under other powers. So it's a retention for examination set of provisions, not for obtaining information.
But I think what Mr. Jaffe seemed to be saying is that there are some circumstances where information is obtained under the IPA and the safeguards under 225, I think it was, could be switched.
Yeah.
And for that subset of Part 7 data, the 10 or so occasions in the last 2 years, they would be cautious. It's not the whole of the Part 7 data sets. It's those who've been acquired under the IPA. But
Can I come to that directly? That is the essence of the point. But just before I get there, to give you a couple of tiny and short points to finish off the initial set of points, as it were. If it solely concerns processing by the SIAs, I submit, it isn't actually within the scope of the e-privacy directive at all. Just that bit of it, because the e-privacy directive, as you know, is directly and only focused on obtaining stuff from the CSPs, and it's only on that basis that it's dragged within the scope of EU law. But as my Lord rightly points out, they argue below and argue now that Part 7 generally may not be within the scope of EU law, seems to be almost accepted, but that BPDs which are derived from the use of other compulsive powers, that's the point you're putting to me, in the IPA and then converted into the BPDs under Part 7 pursuant to Section 225 are within the scope of EU law. So far as that is concerned, Section 225, which you find if you need it at page 2874 of the Authorities Bundle, permits the Secretary of State to direct that an agency may retain, examine and so on, a BPD obtained under other powers in the Act, and that other regulatory provisions then cease to apply. It moves from one bit of the Act to the other. That's the effect of it. But that, we respectfully submit, is not obtaining it from the CSPs. It's simply not a Watson or Privacy International type situation where there's a relevant connection between the retention and obtaining access on the one hand and the subsequent use and safeguards on the other. But rather, this is concerned with moving an existing BPD, lawfully obtained and held under another part of the statutory regime, brackets which does comply with EU law, into the regulatory framework under Part 7. It doesn't involve any interference with the confidentiality of telecommunications.
You use the word moving. It's not really moving, it's
just relabelling.
Recategorising
It
or
is.
relabelling.
My lord, it's true, I used a loose term, but you're right. It is not a kind of formal move, as it were. But it involves, the core point is, it involves no interference with the confidentiality of telecommunications or the activities of CSPs, such as would be necessary to engage the e-privacy directive and all of the case law and safeguards that follow. Moreover, section 225 sub 2 provides that this power doesn't apply to any BPD obtained under a bulk acquisition warrant under chapter 2 of part 6. And that realistically is the only type of BPD that realistically could be argued to be general and indiscriminate, if that's where this argument ultimately leads. So the claimant's case amounts to saying that just because data has originally been retained at some point by the use of a power that has involved requiring a telecoms operator to do something, then anything that happens subsequently to that data must be within the scope of EU law. And that, we respectfully submit, is not a proposition that's supported by Privacy International. In Privacy International, the CJU simply repeated the reasoning in Watson, said that Article 15 of the e-privacy directive must be interpreted as meaning that the scope of EPD extends not only to a legislative measure that requires providers of electronic communication services to retain traffic and location data, but also to legislative measures requiring them to grant the competent national authorities access to that data. That's paragraph 39 of Privacy International, see tab 17, page 639. And that was on the basis that granting access, in that sense, to the state to material retained by the CSPs was a processing operation carried out by the telecoms operators. So national legislation granting access had to rely on objective criteria in order to define the circumstances and conditions on which such access in the hands of the operator was granted. See Privacy International paragraph 78. It would be going a very large amount further than that to say that just because the data had at one point been obtained from a TO under compulsive powers, which itself conforms to the provisions of EU law, anything further done with that data must fall within the scope of it. That would be a very surprising outcome, and indeed a deeply impractical one, it might be thought. How will one know, once intelligence information has been fed into the system, what its original derivation was? I mean, the paths through the marsh become blurred pretty quickly in that respect for obvious reasons. So we submit that retained EU law bites on what was described in paragraph 46 of Privacy International, page 640, in the authorities bundle behind tab 17, para 46 of Privacy. It bites on, as they put it, operations processing personal data carried out by CSPs, including processing operations resulting from obligations imposed on those providers by public authorities. The consequence of that is, if that's the scope of and reach of EU law, which it is, that's the limit of it, where the data has already been obtained by an intelligence service from a CSP under another part of the Act, there's no processing operation by the CSP required at all, if it's thereafter retained and examined pursuant to a direction under Part 7, Section 225. So that's what we say about that issue, to the extent that it truly adds anything of substance, which may be doubtful.
But if they were right, do they need two things? They need to show that you're wrong and they're right on the scope of EU law. They'd still need to show that the bulk personal data sets were general and indiscriminate as well.
They would.
Yeah.
They've got to go through those hoops first.
So it's two stages. Get in and then satisfy the test.
It is. And I've made my submissions on that and don't go back.
Yeah, no, just the layman's then.
So that's EU law ground 1. EU law ground 2 is now formulated places considerable reliance on the pot that, from my learned friend Mr. Jaffe's perspective, appears to keep on giving, which is opinion 115. The argument put in the claimant's skeleton, paragraphs 91 to 97, rests on the proposition that Watson, CJU, Watson, distinguishes between retention and access, putting inverted commas around both of those phrases for reasons I'll come to, and envisages separate authorisation for access on a case-specific basis. So they say the Divisional Court was wrong to say that the initial authorisation of retention under bulk powers is sufficient. That's the way they put it, particularly at paragraph 95.2 of their skeleton. And that involves a clear misreading, we respectfully submit, of the court's judgment in Watson for all of the reasons, which I'm not going to go back on already, set out in our skeleton argument to this court, paragraphs 96 to 98. In oral submissions, the point is now argued principally by reference to the Luxembourg Court's judgment in opinion 115 on the EU-Canada PNR agreement, which is behind tab 16 of the authorities bundle, and I will come to in a second. We still rely for this purpose on our skeleton at the relevant paragraphs I've just identified, 96 to 98, to show that their characterisation of access, that word, is wrong. Watson at CJEU does deal separately with retention and access, but it is using those concepts in this way. Retention, when it's being considered in that judgment, refers to the to regulating or requiring the retention of customer communications data by CSPs. Right, so it's in their hands. That's the retention bit. And the access bit is access to that retained CSP data by the state. So you've got to understand what the CJEU means by access in this context, and it's access by the state to that data. It isn't access in its own hands, as it were. So the reference to access in Watson CJEU is to the ability of national authorities to obtain the retained communications data from CSPs. And that is clear from the relevant reasoning in Watson. Don't invite you to turn it up now, but see, for that purpose, Watson, paragraphs 116 to 118, tab 15, page 554 in the bundle. And critically, given that that's the meaning of access, access in this context does not refer to decisions by national authorities to select or examine items of data that they have obtained and hold already, whether it's obtained lawfully using bulk powers or non-bulk powers. That internal activity of the state was not an issue in Watson. It is not an issue. So I'll turn to opinion 115, the wretched opinion 115, tab 16, page 559, if you would, because it needs a little bit of going through. So page 559, tab 16. Sorry, I'll give you the reference that gets you to the first paragraph I want, which is page 567. 567 should get you to paragraph 21.
The explanatory memorandum.
Yes, sorry, just give me 1 second. Yes, sorry, 561 in the authorities behind tab 15. Sorry, 16. 567. So you see paragraph 21 at the top of the page, I'm hoping.
Yep.
That sets out an extract from the draft agreement memorandum between the EU and Canada. And the point of the agreement, as you see in particular from the second paragraph within the quote, in paragraph 21, so just by the first hole punch notionally, the paragraph beginning this legislation, if you look at the end of that paragraph, you'll see that a core point of the agreement was to provide a legal basis in EU law allowing the airlines to transmit their passengers' personal data to a third country. And ordinarily that isn't permissible under EU law, save in certain circumstances. So that's what it's doing. It's providing a legal basis in that way. The text of the agreement, with that purpose in mind, is set out by the court at paragraph 30. Paragraph 30 begins halfway down page 568. They're pretty little paragraph numbers, but you'll see paragraph 30 there. And the bit I want is on page 572 for this purpose, which is Article 4. So at the top of is a great big long set of pages quoting from the agreement, but 572 Article 4, and you'll see that Article 4.1 requires the EU to ensure that carriers are not prevented from transferring the data, and the transfer is going to be to the Canadian competent authority. That's what's going to happen, see Article 4.1, to the Canadian competent authority. So the full passenger data set provided to that authority is going to be provided to that authority for the purposes set out in Article 3. If you just go back a page and you look at Article 3, back 2 pages to 570, by the notional second hole punch, you will find Article 3. And if you look at Article 3.1, you will see it's being transferred to the Canadian competent authority for the purpose of preventing, detecting, investigating or prosecuting terrorist offences or serious transnational crime. So that's what's being done. Then under Article 18, if you go forward to page 577, you will see that the agreement permits onward disclosure within Canada to other government authorities with directly related functions on a case-by-case basis and subject to necessity requirements and safeguards and so on. You see that from Article 18, sub 1. So that's the context in which the agreement is set up. Those are the provisions which regulate it. So you've got a transfer to the Canadian competent authority and the possibility of them transferring the thing within Canada to other Canadian authorities. Jump then to paragraphs 182 to 3 on page 603 within the reasoning of the court in its opinion. The CJU notes that the details of the Canadian authority are not specified in the agreement, but they'll be notified to the EU. That's 182 to 183.
Thank you.
Or just cast an eye down 182 to 184, if you would, to the end of that. If you just have a quick read of that. So see, they haven't quite got the details of the Canadian authority. They're not specified in the agreement, but they're going to be notified, so that will become clear. And they also note in 184 the provision for sharing with other Canadian government authorities. And they then come to consider at 190 and following, on page 604, the sufficiency of the safeguards around what they call the retention of access to and the use of the data. That's 190 and following. And 190 to 195 is the structure of the judgment. Describes the retention. That's the retention by the Canadian competent authority of the data handed over by the airlines. And then 196 to 203, which include the bits that my learned friend relied upon, I think 201 and 202 he particularly placed reliance on, deals with the retention and use of the PNR data before passengers arrive and while passengers are in Canada. That's what they're doing in those paragraphs. And their conclusions are, in 197, if you just cast an eye down that first of all, that the retention and use of the PNR data to facilitate security checks and border control checks must by its very nature be general, so not restricted to a particular circle of air passengers, and so can't be subject to prior authorisation by a court or an administrative body, independent administrative body. So for that objective, retention and use therefore meets the requirements of strict necessity. That's the first conclusion at 197. 198, similarly, same conclusion, same logic in relation to the retention and use to check the algorithms and the models and so on. Then at 199, cases may arise in which the Canadian competent authority gathers information indicating that the use of the PNR data might be necessary to combat terrorism and serious transnational crime. And the court says, in essence, well, that's okay, but, and we put three little buts in there. First of all, by definition, if you've let them into Canada already, it will be, that sort of use will be based on new circumstances. So it's a distinct access to or use of the retained passenger data beyond the need to facilitate security checks and border control. And therefore, on its own terms, it needs to meet the Watson proportionality requirements. So rules laying down things and safeguarding against abuse. That's paragraph 200. There's also a proviso that you see in 201, provided there's an objective evidential basis relating to the use for that purpose. The use will be strictly necessary, 201. And so far as safeguards are concerned, such use of retained PNR data, that's the phraseology used in 202, and note the use of the word retained, such use of the retained PNR data should, except in case of urgency, be subject to a prior independent review following a reasoned request by the competent authorities. Applying by an...
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
With my lady's permission.
Yes.
We'll continue normal business.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Thomas More building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Might risk it. I was on 202, so I was emphasising the words, the use of retained PNR data with the requirement for prior independent review following a reasoned request by the competent authorities. And they apply Watson by analogy. So Mr. Jaffe seeks to rely on 201 and 202 and the same point in 208 in relation to future storage and use as support for an argument that EU law therefore requires, in the context of the IPA, prior independent authorisation on a case-by-case basis whenever a national authority decides it wants to select or examine items of data that have already been obtained and are already being held under one of the bulk powers in the Act. And I respectfully submit that it's entirely clear that Opinion 115 doesn't help on that. What it's doing is to seek to apply the Watson analysis by analogy to the very specific context of the Canadian PNR agreement, by analogy. That's what it's doing, it's analogizing. And in that context, there is no role for prior independent and judicial authorisation when the PNR is first provided in bulk under the agreement. When you're imposing the requirement for prior authorisation by analogy, the CJU is in effect treating the holding of the PNR data by the Canadian competent authority as a form of retention, if you will, analogous to the retention by the CSPs in Watson. Here it's being retained by the Canadian competent authority rather than being retained by the airlines. And continuing the analogy, the subsequent use of that retained data, which may well involve a request for access by the Canadian police or security agencies, is regarded by the CJU as being analogous to the access addressed in Watson. In other words, the obtaining of the relevant CD from the CSPs. That's the analogy. It on no view, none of this, on any view, supports some broad and general proposition that whenever bulk is examined in the hands of the agencies, it must be subject to prior independent authorisation. It doesn't support that view at all, still less in the context of the IPA, where bulk data will already have been obtained only after a process of prior judicial authorisation that authorises both the obtaining and the subsequent examination of the data for specified operational purposes. But nothing in Opinion 115 could be said to support the need that under EU law you then have some form of continuing requirement that every time you want to look at it or examine it, to use that concept to distinguishing it from access, you end up in this sort of territory. And the same point can be made about the two further decisions on which my learned friend relies. These are both unbinding on the court in any event, given they are delivered post-exit day, but they can be taken into account, no doubt. The GD case, to take that one first of all, that's in bundle 20, sorry, tab 20, page 822, and that's the starting point. But if you go to paragraph 64 on page 855, so tab 20, page 855. And you see paragraph 64, from 64, but here just by way of background, the CJU is considering the general lawfulness of the Irish legislation and whether EU law precluded national legislation that provided for general and indiscriminate retention of traffic indication data for the purpose of combating serious crime. You get that as the context from paragraph 31. At paragraph 64, which was the passage relied on by my learned friend, the CJU is considering the submission that you see recorded at paragraph 60 on page 855. So the submission by the European Commission was that serious crime could be treated in the same way as a threat to national security. And what the Luxembourg court does at 61 to 63 is to say, no, they're not the same. National security and serious crime. We've dealt with that in quadrature. And then at 64, all that it's saying is that it's nothing to the point that the data may be legally the object of retention for the purpose of safeguarding national security. In other words, whilst general and indiscriminate retention for national security may be permissible, that doesn't affect the applicability of the rules generally and that would apply when you're requiring retention for serious crime purposes.
So both of these are new events. In Canada, a new risk arose after they got there, and here a new thing was needed. Instead of being security, it was crime. And if it's a new thing, put in colloquially, not surprising you have the access requirements, but if it's continuation of what you've already been doing, it's okay, you say. Is that right?
Yes, I think that is right. But as fundamentally, this is all about the lawfulness of legislation requiring retention by CSPs. It doesn't establish some sort of general. What he needs is a general principle of EU law that requires independent authorisation at every point at which you examine. It's got nothing to do with that.
It's all about retention.
It's all about retention.
Yes.
It's got no relevance to the point that he was making at all. And exactly the same point can be made in relation to SpaceNet. I don't invite you to turn it up now because it's the same essential point, just cast in a slightly different context. That's in in tab 21, page 871. Mr. Jaffe relies on paragraph 130. And you probably want to read round about 130, 131. Again, it's all about the constraints on either retention or the national authorities obtaining the data from the CSPs. It's not about, certainly doesn't establish anything like a general proposition that every time you want to examine, EU law imposes that requirement for independent prior authorisation. So we submit that the Divisional Court was accordingly right to find that there is no requirement for separate authorisation for examination on a case-specific basis, and that the Watson CJU requirement for prior authorisation for access to retain data, in the sense that I've described, is met by the requirement for approval by a JC of a bulk warrant authorising the obtaining of retained data from the CSPs. That's what's referred to when access is referred to.
And this paragraph 145, the only place where that's dealt with paragraph, I think it's 144, 145 in the 2022 judgment.
It's 145, yes, in the 2022 judgment, page 1030. And I think that conclusion is to some extent reinforced then by the other safeguards relating to the selection for examination that they dealt with in detail in their ECHR judgment, paragraphs 42 to 65. But yes, I think that's the paragraph. So not merely do we say that this proposition of principle advanced by Mr. Jaffe completely misanalyses the Luxembourg case law, but we also note for good measure that to impose the sort of requirement which he contends would be necessary, in other words, prior independent or judicial authorisation for examination each time you go in, would be wholly impractical and unrealistic, particularly given that the main purpose of acquiring bulk data, including for the serious crime purpose, is target discovery. See, for example, Mr. Dix's statement at paragraphs 29 to 32, supplemental bundle, page 57. What that means, in effect, is that the agencies stitch together small bits of information to uncover, for example, the child exploitation networks. And if it was necessary to get independent authorisation every time a new bit of information was uncovered, which might relate to a new individual, then the whole thing falls apart as any sort of fast-moving investigation. So we submit that for good measure, and it's problematic or fatal principled objections to that, because he's misanalyzed the case law, but it would be a very surprising requirement to impose in any event for the reasons I've just given. That leaves me with two topics to deal with. One of them is, the final one is EU law ground 3, which is the charter point. And then finally and briefly, I'm going to come back to the 2642 confidential journalism material that I said I was going to do overnight and give you the best guess on that, if I may. But before I get there, breach of the charter is the final EU law ground. And the point here that is made is that the relevant rights under the EU law charter, which you find behind tab 72, page 3374 if you want it, don't invite you to turn it up now, are at least as extensive as the rights under the ECHR, and so the Divisional Court was obliged to find that any breach of the ECHR was also a breach of EU law. And just to note that the way the point was pursued below, and to some extent still is here, is that the BBW judgment and the defendant's concessions following it required the Divisional Court to give effect to BBW via the route of EU law, so as to render those provisions unlawful under EU law. See, for that purpose, the recitation of the argument at paragraph 150 of the 2022 judgment, 150 of that 2022 judgment, court bundle, tab 31, page 1031. And that argument, put in that way, unsurprisingly perhaps gave rise to some interesting constitutional considerations for the Divisional Court, including the extent to which it might or might not be consistent with Parliament's intention under the HRA and the Withdrawal Act, that an ECHR judgment delivered after 31/12/20 becomes automatically binding in effect on our courts and gives rise to mandatory relief through the back door under the EU Charter. And we submit that the reasoning of the Divisional Court at paragraphs 151 to 158 of their 2022 judgment discloses no error of law in relation to that argument. clearly correct that BBW Grand Chamber was not binding, although they had a duty to take it into account under Section 2 of the HRA. And then all of the other reasons. I'm not going to go through it because that's not the substance of the way in which the point is now put. But we submit that that analysis of the issue put before them in that way was plainly correct in those paragraphs. The argument is now being put in a slightly different way, which is to say, well, unrestrained by the Divisional Court's 2019 ECHR judgment, this court should now apply the Charter or retained EU law directly and make a finding that the Act is in breach of retained EU law, or that the Divisional Court should have gone to that place anyway and taken the BBW Grand Chamber judgment as a hint as to what the right answer might be. They seek to do that because they perceive some real advantage, query whether it exists, some real advantage to them in the remedial scheme that would then follow if it was breach of EU law.
Even if there's no advantage, Parliament has said we've got to apply the Charter. Parliament has told us that, so we're stuck with the Charter. And the question is it a breach of the Charter or not?
Yes, I agree. If that helps. I mean, one can also have, I suppose, a set of arguments, if you really wanted to, about how the findings derived from BBW are said to be characterised properly now as retained EU law. But what I don't want to do is to get sucked into unnecessary debate. If the Divisional Court should have, and if this court has to look at those provisions in substance and to see whether the Charter is breached, we need to be a bit careful. Everyone needs to be a bit careful. I'm not going to maintain a position that says that in relation to those matters that flow from the BBW Grand Chamber judgment, and in relation to which the government, having carefully considered it, has made concessions, that they might not also amount to a breach of EU law, because there is force in the point, I fully recognise, particularly the provisions of the Charter that say it's designed to be a baseline rather than a ceiling. The difficulty that my learned friend confronts is that he seeks to go further than that. But what he seeks to do is to say, actually, you can take the more doubtful points that I have advanced, the points on which the parties disagree about the reach and effect of BBW Grand Chamber, and you can conclude that those are a breach of EU law so as to tee up the remedial consequences that my Lord has just identified. And that, I respectfully submit, is a great deal more difficult. I submit that that's constitutionally extraordinarily problematic. This argument is essentially based, from his perspective, on BBW Grand Chamber having found certain things. And there is therefore, he says, a crossover, that's the substance of the argument under the Charter, there's therefore a crossover that says that must therefore be a breach of EU law. But if the extent of what BBW has found is controversial, then analysed from the perspective of the HRA, you are immediately into territory that I explained at the beginning from a constitutional perspective, which is that there are constraints on what the domestic court can do, principally the constraints derived from ULA and AB. You have to be fully confident. And unless you're fully confident, you should not jump to a position of saying, well, Strasbourg would definitely say that. And if that's right, then the government, in relation to those areas where, having carefully considered matters, has not made a concession, those we respectfully submit are at the very least matters on which you can't be fully confident. And the consequence of that is that the provisions of the HRA and the constraints that exist under the HRA, including AB, should apply. And so what we submit would be constitutional heresy, would be for you to take an argument that even on my learned friend's case...
Attention please. Attention please. This is the incident control officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the incident control officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
I was on constitutional heresy.
Yes.
What you can't do is to take doubtful points on which you are not properly entitled to be fully confident applying the ULA and the AB approach under the HRA, and as it were, determine them for yourselves under EU law. Indeed, I don't think that's the way my learned friend puts it. His premise for the EU law charter argument is that there has in fact been a breach. And if there are areas of controversy, my submission is that you can't properly obviate or swerve around the constitutional constraints that are built into the HRA as now analysed by the Supreme Court in AB and in the ULA cases. So if and to the extent that we have not conceded the point, I do not make any formal concession of any description under EU law, if that makes sense. So that's the way we put it. You've got to start with the ECHR, you've got to start with the HRA, you apply all of that approach, and indeed on the argument, it's only if you get to that point and you say it will be a breach not to do this, therefore you can be fully confident that Strasbourg would say it's a breach, you've got to do this. Only if you get to that point that the corollary argument works.
This isn't really what we used to do, interpret EU law and decide whether provision A meant X or Y. This is really decide what ECHR law means, and the only reason why we think there's a breach of Article 7 or 11 you say is because of the a priori thing. And if we're not sure of that, we shouldn't say, well, never mind.
Exactly so, particularly given the level and care and directness of the consideration that Strasbourg has given this. I mean, I could put the point in a slightly broader way by saying, unless and until you get to the point of clarification of those issues by Strasbourg, you, on no view, can be confident that Luxembourg, with all its independent mind and all the rest of it, and even allowing for Article 52.3 of the Charter, would reach the same outcome, or would reach a different outcome.
But normally the EU law, we'd have to decide it for ourselves. I mean,
yes, but the
with
way in which
you
this
actually do decide it yourself.
That's true, but the way in which this argument is presented entirely properly is it follows from BBW Grand Chamber that this is what Luxembourg would decide. Well, leaving aside the more general point, as I say, that Luxembourg has its own mind. True it is that its own mind normally leads it to a worse place than a better place, but it nevertheless has its own mind. But my point at the more fundamental level is that this argument is premised on the fact that BBW requires these changes. My own friend will say, well, it doesn't, you're still under the obligation, at which point my answer is, you can't possibly be satisfied that Luxembourg will go to a place at Strasbourg that you couldn't be fully confident that Strasbourg would go to. You get to the same place through that slightly different route, but my primary argument is you can't swerve AB by shouting loudly EU law. So that's what we said about that. I suspect I might be able to do the remaining issue under 264 unless there's any other issues on that.
But just one thing, but even on the concession, if we were to accept that the concession meant that there should be a remedy under EU law, is there going to be a separate set of submissions on what remedy should there be for a breach, or is it?
Well, I suppose there might be, although I mean, if there's going to be a debate of that kind, it might be a pretty desultory debate because
You've done it or you're doing it.
Yeah, because the Divisional Court, I remember Lord Justice Singh being very exercised at one point in history about whether or not there was the ability to do declarations with suspension and do the sorts of things that would equiparate to a declaration of incompatibility, even though having a bit more formal force. And he was very worried about whether you could do that. But you've seen the resolution of that in the 2018 judgment, and they conclude, yes, you can. You can have a declaration and you can suspend. So the provision would be one of reasonable time. And
But we're not being asked at this stage, are we?
You're not being asked at
so
this
I don't need
stage.
to worry about it for the moment.
I don't think you need to worry about it for the moment. I mean, no doubt there may be a desultory debate in the future about what reasonableness requires here. But the reality is that the government has plainly and unsurprisingly accepting that if you get to a place where it's clear what Strasbourg is going to decide and that's the final word, then they're proposing to change the law to make sure that that is put right. And it's plainly appropriate not merely to wait for the resolution of that issue at the domestic court level, but to try and do all of the changes that are required in one go. Otherwise you just have a kind of recipe for chaos. So it's not quite the situation we were in when we were dealing with OCGD or whatever it was, the body that was set up, the OCTA body, because that required new administrative structures and all of that. But we're in similar territories. I very much hope we won't have a silly debate about how long is a reasonable time, but that is the potential consequence. My lord is right. Can I have one more go at the source? Is the source protected issue? Right. So for this purpose, you need the Act again, and you need sections 264 and 263. The issue, in a nutshell, so sorry, that's 2925 takes you to 264, and the source of journalistic information is at 2923. You'll remember that in the definition. Is that how they marry together is the question. So the issue is whether the language of 2645 has the effect of transposing the carve-out for criminal material into the definition of a source for journalistic information on page 2923 within section 263. And we submit the answer is no. The Act at 264 sub 2 defines journalistic material as a concept for the purposes of the entire Act. See section 2641 as material created or acquired for the purposes of journalism. And CJM, confidential journalistic material, is a subset of journalistic material. See 264 sub 6. For the purposes of 264 only, see the beginning words of 2645, material will not be regarded as created or acquired for the purposes of journalism, so will not meet the definition of journalistic material if either it's created with the intention of furthering a criminal purpose or it's intended to be used to further a criminal purpose. That's 2645 A and B. So you then turn back to 2631, see if that translates. That defines source of journalistic information, not of journalistic material, as an individual who provides material, again not journalistic material, and does so intending to use the words in 263, the recipient to use it for the purposes of journalism or knowing that it's likely to be used. So we submit that a person is not prevented from being a source within 263 because the information they provide falls within the criminality exception of 2645. A source within 263 is a source of, quote, journalistic information, not journalistic material. They provide material, but not journalistic material. And journalistic information is not a defined term. A deeming provision in 2645 as to when material is regarded as created or acquired for the purposes of journalism only applies for the purposes of 264 itself. See the beginning words of 2645. So although it carries over into the definition of journalistic material, which applies across the whole of the Act, it does not carry over into the phrase for the purposes of journalism in 263. And it follows, therefore, that the source of journalistic information in 263 can be a source, notwithstanding that they provide information criminally. And I'm instructed that that's how the agencies understand and currently apply the Act.
And the consequences in terms of, you know, can you give us a real?
The consequence is that the source remains protected.
All the safeguards will
All
apply.
the safeguards apply.
Yeah. They wouldn't apply to the content of the journalist. You
Yeah.
can read the fact that he's got the textbook,
Yeah,
but you can't get the source, you say,
yeah, I do.
I think.
I do.
Yeah.
And we're back to the debate we had yesterday. But that's how we say that, and it's a bit complicated, but that's how we at least say the sections might apply when read together for the court to decide whether that's right or wrong. But that's how we put it.
Am I being very slow? Is the distinction that you're trying to emphasise that it doesn't really matter what the origin or the purpose of the information that was being passed? The person is still a source if he satisfies the definition in section 263.
Yeah.
Full stop.
Yeah,
That's it.
that's it. And that is you don't have the cutout.
Okay, well in that case perhaps I'm not completely confused.
No, you don't have, that's a short way of putting it, but you don't have the cutout under 2645. And the policy reason was the one we discussed yesterday. It's the difference.
Yeah.
So the civil servant who hands over the nuclear secrets to the journalist is all right, but the journalist isn't all right.
Yeah. Exactly.
Criminal purpose, if it's a criminal.
If it's a criminal purpose, yes.
Yeah. My lords, I'm done. Can I reserve the right to have a minute if I need it after 2 o'clock? But
Very
if,
much.
if I am done, then you've got some reply from the other side. I'm not conferring implicit permission on them to go on for 2 1/4 hours.
No.
We've only got 3 quarters.
Well, neither are we. We'll sit again at 2.